Right guys, I might just make a start. My name's Daniel Colton. I'm the Mining and Coal Seam Gas Officer with New South Wales Farmers, and I'll be taking you guys through the webinar tonight. Now, essentially, just as a starting point, those are my details. I'm best reached either by my landline, 9 to 5 Monday to Friday, or via email. The outline of tonight's presentation is there. Essentially, I'm just going to go through what the changes are, why we had them, a couple of changes to the law that have come through, a big important code of practice that's come through with respect to the community consultation, what's sort of effective and not effective now, and then briefly going to touch on the protest laws that have changed very recently. In terms of how I'm going to run it, guys, I've got a reasonable number of people on tonight. If I get time, and the last few webinars I've run, we haven't quite had time, I might take questions at the end, but the system is a bit difficult to take questions on, so usually the best option is to simply email me afterwards, and then I can give you a better answer then, rather than trying to rush through it towards the end. So why have we had a series of changes in the last 6 months? Essentially, it's because the government has conducted a number of reviews and inquiries that have said that the law should change. Chief amongst those are these, being the Chief Scientist and Engineers report, which looked at coal seam gas legislation and changes to the coal seam gas regulation. Brett Walker's review of land access and compensation, which, as the title says, looked at land access issues in New South Wales with respect to mining and coal seam gas. The Independent Commission Against Corruption, which made a number of recommendations with respect to corruption with respect to coal licenses, and sort of stemming from that, the Coal Exploration Steering Group, which looked at coal license allocations. So the Chief Scientist review of mining and coal seam gas looked at the health and environmental impacts of mining, of coal seam gas specifically. Now, the review looked at a number of things was done principally by the Chief Scientist in order to try and get an independent perspective, and it came back with a number of recommendations. Essentially, what it said was that the Chief Scientist's view was that coal seam gas was safe, provided that a number of conditions or recommendations were followed through with in relation to proper engineering of wells and well sites, creation of data, use of a data repository with relation to where coal seam gas wells were. Previously, we've not had the best data with respect to where those wells have been sunk, particularly about 20 or 30 years ago. A well-trained workforce, which naturally comes with also technological developments, i.e. essentially it recommended use of best practice in terms of coal seam gas in order to alleviate as much of those concerns and as many of those risks as possible. The Walker Review, as I said, looked at land access issues, and while it was titled Land Access Arbitration, it looked at all the steps from negotiating a land access agreement right through to the arbitration and appeal process through the courts. Essentially, that review was done by a barrister, Brett Walker, who is a very competent barrister who worked a lot in this area. And the government endorsed those recommendations, and I'll go through the effect of those recommendations later in the presentation, and is in the process of implementing those. And as I said, those recommendations are that the mediation process be separate to arbitration. Previously, they sort of ran together, and previously they were conducted by the same person. Well, Walker essentially suggested that they be separate. He also recommended site inspections. So prior to these recommendations, and still currently is the position that you cannot, that an arbitrator or a mediator is not required to attend your property or a particular coal seam gas site to inspect what's going on, which is a relatively common practice in other areas of land and property and planning litigation. So essentially that sort of brought that in line, or aiming to bring that in line with that sort of thing. He also recommended that negotiations and arbitrations should principally be conducted in good faith, as most people who've been in this space for a while appreciate. There's quite a divided atmosphere with respect to disputes around this, and Brett Walker essentially took the view that when these arbitrations and negotiations are conducted, they should be done fairly and in good faith, not with at 50 paces sort of deal. In addition to that, he suggested that anonymous publication of land access arrangements should be done. Essentially, that was because at the time, and this is actually still the case, we know very little, or there's very little public information about the access arrangements that are in place, and farmers who are approached have very little sort of template or precedent from which they can work and say, well my agreement's fair, or my agreement's not fair, and why, and what areas need improving. Brett essentially said that if you've got a bank of arrangements, that you would be able to better inform landholders and indeed explorers about what is usual and what is best practice in terms of land access arrangements. He also suggested improvements to and the development of a list in relation to experts for baseline reporting. Now, baseline reporting very quickly is sort of that before snapshot of a property before it's impacted by coal seam gas or mining or exploration rather, and so it's sort of that line from which you can judge any sort of impacts to the property from an environmental sense, whether water has been affected, or land or soil, or any of those sort of things have been affected by the exploration activity that's occurred on the property. He also looked at the issue of significant improvements. Now, significant improvements has been in the media this week, and I'm not going to look at that or comment on that. But essentially, he said that the definition of significant improvements, as it stands, is very unclear. It often has to be litigated through the courts rather than being codified, and he recommended that it be codified. ICAC. Most people will have heard of ICAC. ICAC is the Independent Commission Against Corruption, and as part of its investigations, it looked at the allocation of coal exploration licenses, particularly and looked at what incentives there were for corruption in that process. And since then, there's been a lot of work done to try and avoid or severely limit any potential for corruption in that process, which flows on to the Coal Exploration Steering Group, which essentially looked at ICAC's recommendations and produced a more thorough sort of explanation of where we should go, developed a series of proposals for the government to look at, including what I've mentioned there, the strategic release framework, which is part of the changes that I'll be going through. So the bills. Now, essentially, flowing from those from those reports there was a number of initiatives, including the gas plan, including improved management of exploration regulation, which was a New South Wales government policy, but it also led to, more recently, a series of legislative amendments that sort of codified and implemented the gas plan and IMER and recommendations that came in this report. So the bills were passed in October of last year, and then since that time they've slowly come into effect. A good chunk came in December, another chunk came in March of this year, and then the very final bit, which is the land access provisions, will be coming in the intention currently is to put them in July. So there's 5 bills, essentially looking at 5 different issues. I'm only going to touch on the first 3 in detail because the last 2 are sort of not particularly relevant for landholders. They do affect the system, but they're not of direct relevance to landholders. So the first one there is the Grant of Coal and Petroleum Prospecting Titles Bill. That one is, as the name suggests, looks at those issues around the grant of coal and petroleum licenses and the corruption, and sets up a new process for how they are granted. The Harmonization Bill essentially is a quick bill that's well, not a quick bill, it's quite a lengthy bill that attempts to combine both the mining and petroleum acts so that they're more equal in the way that they treat things, and they are more, as it says, harmonious in how they operate. The Mining and Petroleum Amendment Land Access Arbitration is, as it says, deals with land access, and then the enforcement in work health and safety essentially deal with the enforcement bill deals with penalties and such for mining and petroleum producers and explorers with respect to fines and things like that. And the Work Health and Safety Bill simply aligns work health and safety protocols and legislation with other work health and safety legislation. So the grant of coal and CSG changes how coal and petroleum licenses are granted in New South Wales. It sets up what's called the Strategic Release Framework. Now, the Strategic Release Framework replaces the old tender process for coal. So essentially how the system used to work was that a coal explorer would come to the government with a map and say, I want to explore this particular area. And the government would then set out a tender process for that area, but oftentimes, other explorers weren't thinking about that area, or they weren't, or because, it had come up all of a sudden, they weren't in a position to put forth a viable tender, and in particular, if somebody has already started looking at it, they're naturally in a sort of forward position, and that, because it did that, and in addition, the sort of decision-making as to what tenderer would gain that exploration license was not as not as clear and not as transparent. The process was naturally predisposed to corruption, which ultimately I found did occur in some instances. Now selection is via a competitive process, which that bill has set up. So, as I said, effective from last year, essentially what it does is rather than an explorer coming to the government with a particular area, the government undertakes various studies through a number of committees and bodies that it has, or a particular body that it has, and sets out a particular area for exploration. It will then advertise that out to explorers and invite applications. The government will then consider through what is a far more codified process now, a series of criteria which those applications will be assessed by, and then ultimately the framework will allow for a particular explorer to gain that license, but only after they've met a number of criteria and been assessed as competent and best able to use that resource and use their exploration skills to do that. As I've noted there, though, we're yet to actually see this in operation. While the legislation is all there, and a large part of the regulations and codes are there, although there are still a number that are being updated, we haven't actually seen a strategic release area occur yet, largely because there's not a lot of activity in the exploration area at the moment. So we're sort of watch and wait as to how that's all going to operate. The Harmonization Bill, as it says, intends to harmonise the Mining and Petroleum Acts. Previously, they had a degree of inconsistency, and whichever one you were working from, it was often a bit confusing as to what why the systems didn't line up. And that this harmonization bill is designed to line everything up and make everything far more logical and far more, the term is resource blind, far more so that whether it's petroleum, coal or other minerals, the system is the same. Essentially what it does though is increases the variety of compliance tools that are available, so whether that be fines, whether that be court action, whether that be some sort of other civil penalty, whether that merely be a warning, it increases that and harmonizes that between the two acts. It sets a maximum period of 6 years for expiration for a prospecting title and provides for annual reports of expiration to be publicly available after 5 years. So previously, those reports have not been publicly available. Yes, they're submitted to the Division of Resource and Energy, but they're not necessarily publicly available. Now they will be as part of an increased transparency process. The Harmonization Bill, as I said, is now in effect, and essentially it's an attempt to go towards a Single Resources Act, go towards having essentially the Petroleum and Mining Act rather than Petroleum Act and the Mining Act. Land Access Arbitration Bill, this bill essentially is largely based on WUCA. It's not yet in force, and largely that's because they are still working on determining a series of cost caps, which I'll explain in a minute. But it is intended to be implemented on 1 July of this year. So there are a number of changes in that act that are possibly important to you guys. One of them is that land access previously only applied to mining exploration and petroleum exploration. It now applies to mining exploration, petroleum exploration, and petroleum production. That's the added bit, which makes sense because in general, exploration for minerals, be it coal or another mineral, when they get to the production stage, often land is purchased or acquired and in full, and then whether it be open cut or underground is dealt with in that way. Whereas in gas production, often properties are not purchased in full because the wells don't take up the entire property. They're often scattered around the property. So often farming is still possible, although sometimes not. But it's not necessary to buy up the whole property. So often that's not what occurs. So they've sort of translated that access arrangement position into gas production. The big one that most people look to with these changes is an expansion of the costs that are recoverable by landholders in the negotiation, mediation, and arbitration of land access arrangements. Previously, landholders were only, and even currently, landholders are only able to recover the costs of initial legal advice. The legislation is very clear on that respect. They can, of course, negotiate to get more, and in a previous webinar I've explained all that with relation to costs. These changes, when they're implemented, will allow landholders to recover costs for the whole process and will widen the costs to include landholder time and costs for landholders, as well as the cost of legal advice and the cost of experts. That said, that's all couched in the potential for those costs to be capped, which, as I said, is currently the issue that's being negotiated as to what those caps will be, where they'll apply, and how high or low they will be. Another change, which I've also foreshadowed, is the definition of significant development. As I said, it was previously quite troublesome in that often people were running off to court to find out whether a particular fence or a roadway or fence or irrigation piece was a significant development. This attempt here essentially creates a 4-step test for what is significant development, and also allows for the government to deem certain things as always being significant development, which it's hoped will make the whole process far more clear, far more transparent, far more open. Changes to roadside seismic surveys. Essentially, previously your consent was required if seismic surveys were done within 200 meters of your dwelling. That has been removed such that you only is required notice now. Now, you still require that consent if it's on your property. This change only affects roadside seismic surveys or surveys that are not conducted on your property. They're conducted on adjacent roadway or clearing. It also makes changes to the arbitration process. So as part of that, things like things such as the requirements for arbitrators and a list of arbitrators will be developed, and a code of arbitration which will set out things like the process for arbitration, how an arbitration should be conducted, what represents it, what represents arbitration and mediation in good faith, and sets out the processes for all of that. Those are those changes. The enforcement of gas legislation, as I say, I'm only going to briefly touch on this, extends powers of investigation to the Environmental Protection Authority. The Environmental Protection Authority recently got power with respect to petroleum offences. That was part of the New South Wales gas plan. And so these pieces of legislation essentially enshrine that and extend those powers that the EPA has as a regulator for the petroleum industry. And as I said, it allows the EPA to issue things like cleanup notices and remedy notices and fines and all those sort of things. And that piece of legislation, as I said, is currently in force. Work health and safety, I'm going to be even briefer on this, essentially aligns the health and safety requirements for minerals and production with the rest of the work health and safety regulatory framework across other industries and between those two industries, and provides that specific industry regulation. The Community Consultation Code. The Community Consultation Code I'll go back a step. The Community Consultation Code applies to exploration activities and sets out the requirements for explorers with respect to what they must do with community consultation. Now, that said, it actually doesn't set out specific requirements in the sense that it doesn't say that you must provide a newsletter, it doesn't say that you must hold X number of community forums, it doesn't say that you must contact X stakeholder groups. What it does is it sets out a framework for impact versus level of compensation. So what it sets out is that consultation must reflect the level of impact that there is going to be to the community or environment. So if a particular exploration activity is particularly low level, it's over a wide area, but it's all low impact, it's potentially only a geologist walking in paddocks and kicking a few rocks over, then the level of consultation for that is going to be significantly less than if a explorer is seeking to do a number of high intensity and quite deep boreholes across a number of properties in the area. And so that community consultation has to reflect the impact. So in some instances, that community consultation could potentially only be a notice in the local paper or a letter out to a number of landholders or something along that line, or it could be a full-blown series of community consultation forums, newsletter updates, all those sort of things. And so essentially it just turns on that level of impact that it's going to have. That said, the way that that is sort of regulated is through annual reporting to the Division of Resources and Energy and Government. So each year, an explorer must provide what they've done, whether it's their community forums, whether it's a newsletter, all those sort of things to the government, and the government then assesses that against the original plan and the original exploration activities to see whether it meets the guidelines that the government has with respect to community consultation. What's in force now? Essentially, it's almost all in force, except for the land access provisions, which is outstanding. And as I say, we're currently waiting on the development of those cost caps, and those cost caps are in relation to the elements of mediation, negotiation and arbitration, and what they're going to apply to. Essentially, those cost caps are being negotiated by a number of stakeholders, including the Minerals Council, New South Wales Farmers, APR, and a number of other stakeholders. And that group is chaired by Jock Laurie, the Land and Water Commissioner, and essentially it's expected that in July, those cost caps will be implemented. Amendments to the protest laws. As I said, I'm going to be relatively quick with respect to these and just sort of flagging what they are. Essentially, there are three changes that were made with respect to the protest laws. One, they created the new offence of aggravated trespass. Now, essentially what that means is that all the other normal elements of trespass, be it essentially that unlawful entry, the aggravating factor here is where it is unsafe to protesters, workers, and the community, or interferes with the lawful conduct of a business. So that is that aggravating factor, and that is what sets that trespass offence apart and puts the extra penalties that are associated with that trespass offence. In addition to that, they have broadened the definition of what a mine is with respect to the offence of interfere with a mine. So previously it was always the offence of interfere with a mine, whether somebody does something with respect to sabotaging or anything like that. And what they've done is essentially expanded to what they consider is the modern definition of a mine. So it includes, or has the potential to include, things like exploration activities. It includes petroleum wells and sites, which it didn't previously do, and it also covers the other end of the spectrum, so rehabilitation work and things like that as well. The third area on which the changes were made were with respect to police powers. Now, these powers actually apply beyond the mining and coal seam gas space, but just with reference here, essentially what they did was allow police to seize, search, and dispose of what is referred to as lock-on equipment, which is defined under the Act, and it is equipment that is intended to be used for the interference with a business and is likely to give rise to a serious risk to safety. So it needs both those elements. It needs that interfere with business, and it also needs to be a serious risk to safety. They also gave police additional move along powers. So police have always had, in certain circumstances, the power to move people along if they're causing some sort of nuisance or under a very specific set of guidelines that the police have had. What they now have is they can move people along where there is a serious risk to a person's safety, or where it obstructs traffic. Now, both of those are couched in that more restricted police powers, whereby they have duties of care and all those sort of things, but they've essentially just removed what were previously restrictions with respect to serious risk to safety and where it obstructs traffic. And essentially given police two more reasons under which they can move people along. Now that's gone relatively quickly, guys, but as I say, there are a high number of people here, and I'm not really comfortable with the sort of question and answer system on this webinar. So what I'll say is that there will be a follow-up email, likely on Monday because I'm out of the office tomorrow, and that will contain a link to this presentation, a link to a number of resources that relate to this stuff, as well as a copy of the survey, a quick survey that we're getting done, and just a copy of these slides as well. And if you can fill out that survey, that would be awesome. And as I say, after I send out that email, or even before, if you've got my details already, I'm more than happy to get and take any of your questions. More than happy to take calls, even if it's straight after this, and just because I feel that it's easier to talk through these issues with you guys one-on-one. Because often people have asked me quite specific and questions that relate quite specifically to their circumstances. So thanks, guys, and I will be in touch later.